Ladies and gentlemen of the Senate, this is Senate Bill 1240. It is a 111-page bill, and my job here today is to walk you through it and help you understand what it is you'll be voting on. From pages about 80 to 111, those are all just code changes that were made because of the previous 79 to 80 pages. When references to other code sections were changed, we had to change them throughout the code. So it's really an 80-page bill, still a challenge, but let me walk you through what this is. This is a comprehensive update to our guardianship and conservatorship statutes. So a guardianship, it's a court appointment that authorizes a guardian to make personal decisions for an incapacitated person who lacks sufficient understanding or capacity to make or communicate responsible decisions about their health, safety, and daily needs. A conservatorship, it's a court-supervised fiduciary arrangement in which a conservator is appointed to manage the financial affairs and property of a person who is unable to manage assets effectively due to mental or physical impairment and whose property is at risk of waste or exploitation. So similar concepts, the court is involved in each. There's somebody who is appointed to do the day-to-day work on it. Just think of conservatorships as dealing with money and real property, and guardianships as dealing with everything else, health decisions, things like that. We have not done a update of our guardianship laws, a comprehensive one at least, since 1972. Some states did it in 1997, but Idaho did not, and I'm not sure why that was. So this has been a long time coming, thus the explanation for why there are so many changes. The bill mainly makes changes to the Uniform Probate Code, so that's Title 15, Chapter 5, and the care and treatment of individuals with developmental disabilities, that's Title 66, Chapter 4. Essentially, the bill is an attempt to take the best practices throughout the United States and to implement them in Idaho law, consistent with Idaho law. Because this was such a big undertaking, I will tell you we slow-walked this bill. For the last 2 legislative sessions, we simply introduced it. And each time we introduced it, if you've ever been involved in one of these big rewrites, people hear about it late and they show up late. Even though you feel like you've talked to everybody, somebody else comes up late and says, "Oh, I just heard about this. Can we sit down and talk about this?" So we did that, and we did that for actually the last 3 years. But we introduced it the last 2 years. This year, we went forward with the hearing. We feel we have done a comprehensive job of talking to anybody and everybody who's interested in this issue. And I should tell you, Bob Aldridge, who's an estate planning attorney with 50 years of experience, has been heavily involved in this. Lisa Anderson from AARP has been heavily involved with this. Amy Cunningham, who has spent decades in the specialized field of disability law and is the executive director of Disability Rights of Idaho, has been heavily involved in this. These are the groups that we have talked with. TEPI, that's an organization that has 70 persons and entities from a wide cross-section of Idaho, including trust departments, attorneys, social workers, health and welfare, CPAs, and many more. The taxation, probate, and trust section of the Idaho Bar, the Supreme Court guardianship and conservatorship group, and then Idaho Bankers Association, the Idaho Trial Lawyers Association, the Idaho Department of Finance, the Idaho Guardians and Fiduciaries Association, Idaho Continuum Care Association, Idaho Association of Counties, Uniform Laws Commission, Idaho Health and Welfare Courts and Crisis Team, and the Boise Estate Planning Council. I tell you all that because I get it. It's a little nerve-wracking to vote on a big bill on a topic that you don't know a lot about. But at least in my view, when I have to consider and vote on something like this, I lean on the fact that other organizations who know a lot more about this than I do have looked at it, feel comfortable with it, have asked for changes, received those changes, and that's what we have here. We have made many changes to this bill as we've taken input from these different organizations, and I think it's made it a much, much better bill. I would also tell you we've extended the implementation date to January 1st, 2027. As you know, that's odd, but we did that because the courts asked us to do it, and many of the organizations I mentioned also want it. It's going to take some time to train judges, attorneys, others that deal with these issues to get on top of these new changes, but they've been very well received. There are a few practitioners in the conservatorship and guardianship, and I mean lawyers, who I think this will kind of push them out into retirement because they know the old way, they don't want to learn the new way. But a lot of younger attorneys see the wisdom in these changes, as do the older attorneys, and they're eager to practice under the new laws. Let me give you just a little bit of information about what's in those 80 pages that I think you'll find helpful as you get ready to vote on this bill. The group I mentioned that I've been working with, they've actually been working on this for about 5 years with various groups. This bill adds further protections on multiple levels for those involved in the guardianship and conservatorship process. It provides clarity in certain areas of our guardianship and conservatorship laws where questions have arisen under the current code, so needs for changes. It provides multiple detailed alternatives to formal guardianship and conservatorship court proceedings. That is one of the best features in my mind of the bill. Sometimes you have somebody who could use some help to get through a tough time, but they really don't need to give up all their rights. They just need a different vehicle. This bill provides different vehicles that can be used by the courts to, tailor to the particular needs of the individual. This bill retains multiple Idaho procedures that are working well. It requires detailed information at the beginning of a guardianship or conservatorship process under the code and protects the constitutional rights of persons subject to these guardianships and conservatorships. Let's see. The fiscal note, there is no cost. The courts have expressed some concern that it may increase the workload of the judges. We don't see it that way, and we really just have to implement the bill and the statutes and see what happens, but I don't think that'll happen. That is the essence of the bill. It's a good bill. We worked hard on it to get it right, and I feel like we've done that, and I would appreciate your support. Thank you.
Thank you, Senator. Is there further debate?
Mr. President.